degree, which is violent and most serious, carries 15 to life. He is also here on resisting arrest A, and the state may be directing indicting for a malicious injury to personal property. Your Honor, the state is asking that bond be denied. Not only is he a flight risk because of his charges that carry a life sentence, Your Honor, he also has pending charges that I will get into later. The state does believe that he would abscond and he is a danger to his grandmother. The facts of the case are that on July 14, 2025, Sheriff's Office responded to in reference to a possible burglary in progress around 2 a.m. Law enforcement observed articles of clothing, a suitcase, a cell phone sitting in the driveway of the residence. Law enforcement was notified that the defendant had live streamed himself via TikTok, breaking into his grandmother's home. Law enforcement was able to make contact with the owner of the residence, and this was around again 2 a.m., Your Honor. She was sleeping, who stated that the defendant did not have permission to be there and she allowed law enforcement to enter her residence. Ms. Bruce mentioned something that the defendant was trying to get in with a butter knife within the residence. Deputy Keeling used the PA system to call out the defendant, who had barricaded himself in the laundry room and the garage. The defendant was seen opening the window to the laundry room, giving the perception that he was attempting to flee from the area. Law enforcement attempted to spray pepper spray into the open window, but the defendant closed and locked the window. These tactics became unsuccessful. Thus, the law enforcement brought a canine unit, Your Honor, onto the scene. Defendant was informed he was under arrest for burglary. He refused to come out or obey lawful orders. The SWAT team arrived, took over the scene and operation. It was after continuous negotiations and deploying 2 cans of CS vapor did the defendant then surrender. Your Honor, this all took place approximately within a time range of 5 hours. Your Honor, if I may also include, those are the facts of the burglary and the resisting arrest. I had our investigator from our office check into the outstanding bench warrants, Your Honor. It looks like from New Orleans, he has a battery to police officer and simple battery ×3. To be honest with the court, I don't know if it's a 1 count of battery to law enforcement officers and simple assault battery, those are separate, or if all of the officers were the victims on those 3 counts. And there's criminal damage to property ×2 as well. Further, Your Honor, if I may look at my phone, our investigator was looking into the jail calls that were made. It looks like he was attempting to talk to his mom, to talk to the grandma about signing an affidavit that he wasn't there to commit a crime. So he's making a lot of jail calls, trying to get in touch as well with the grandmother, from my understanding. Your Honor, he has an extensive criminal history in 2010, shoplifting, 2011, possession of beer, failure to comply ×2, assault and battery 3rd degree, 2012, possession of controlled substance 1st offense, domestic violence 1st degree, out in Louisiana in 2015, possession of heroin, violation of protective order, 2018 from Louisiana, possession of Schedule 1, 2019, PDC, in 2021, possession of meth, cocaine-based 1st offense. Your Honor, I did want to be clear with the court. There were some arrests within Louisiana that the state does not know if it's pending, Your Honor, the disposition, so I'm not calling these out as convictions. But what the state will be verifying, there was a domestic abuse battery, domestic abuse battery by strangulation, false imprisonment, unauthorized entry in inhabited dwelling. So he has done this in the past, at least been arrested for it, Judge. Lastly, if I may give the victim input, she is not here due to her age and difficulty to get into court, Your Honor. She says that she's not going to protest against him getting released. She just didn't want him near him. But after speaking with the victim's daughter over the phone yesterday, Your Honor, she said that Miss Bruce is afraid of her grandson, even though she does love him very much. She mentioned that although the defendant lived with a grandmother in the past, this was around high school. Miss Bruce's residence is not his current residence, although he used to sit in his ID. I believe that he is unhoused. The victim was inside the home sleeping when this took place. The victim's daughter also informed the state that while the defendant has been in jail, he has been trying to call their grandmother to drop the charges. He does have a violent history, Your Honor. Those are the reasons that the state believes that even if he were granted bond, Your Honor, he would be absconding since he has those Louisiana charges, and the state is asking to deny bond altogether. Thank you.
Okay, thank you. And I want to make sure I understand, but right now, bond has not been granted on any charge?
That's correct, Your Honor.
So there is not a no contact in place right now. So he has not violated bond yet.
That's correct.
Okay. I just want to make sure that, but Mr. Harris needs to understand that any order that is issued in the future would include a no contact. Okay. Yes, sir.
May it please the court, Your Honor. This is the defendant's initial motion for bond. As stated, Mr. Harris was arrested July 14th, charged with burglary first as well as resisting arrest under subsection A. While these charges are serious, the law does not mandate a denial of bond. Mr. Harris is 32 years old and would be the first to admit that he has made mistakes in the past. The last charge that the assistant solicitor read out, Mr. Harris actually served time for that. Despite the mistakes that he has made, he has been working diligently on his sobriety journey, as well as his mental well-being, all while helping others through his platform on social media. The incident that led to these charges is something that Mr. Harris did not anticipate. When he, in a moment of desperation and fear for his safety, went to the only place that he knew that he would be safe, which would be his grandmother's house. He grew up in that house. He called law enforcement on the way over there, as well as being live on social media during that time. Mr. Harris states that he did go in through the unlocked door into the laundry room. He knows now that maybe he should have just went to the hospital. He was suffering sort of a mental break during that time. Mr. Harris, as I mentioned, grew up in that house, and as the assistant solicitor mentioned, that is the address that he has on his state-issued ID. He does have some items still in that house. I've spoken with his grandmother, as well as his family. They all believe that Mr. Harris does need some help. He is not a flight risk. He was living in Greenville, and he poses no threat to the community. He has support from his mother's side of the family, which would be able to assist in housing, as well as some friends that live in this area. Mr. Harris does plan on going into a rehab, should Your Honor grant some bond. He was gainfully employed prior to his incarceration. He actually was just getting hired on permanently with the Food Lion distribution. He is committed to going to AA, sober living, as well as using his social media platform to help others in their journey to sobriety. He is committed to doing community service, and he wanted the court to be aware of that. He has a goal of setting up his own sober living facility, and I know he has several financial backers to help with that goal. Your Honor, Mr. Harris is willing to submit to any reasonable conditions the court sees necessary for his release. That would include no contact with the alleged victim, being his grandmother. I believe he actually got in trouble for making some of those calls at the detention center and was in solitary without any way to be able to communicate with anyone for, I believe, the last 30 days or so. He is aware of the issues surrounding being, contacting individuals as it relates to this case. He is committed not to make those phone calls, to the victim. He is willing to do home detention, GPS, any drug, alcohol monitoring, and any other conditions that the court deems appropriate. At the end of the day, Your Honor, my client did not intend for this to happen. It was all done in a moment of need, and he was fearing for his safety at that time. Thank you, Judge.
Okay, and please, Mr. Harris, don't be offended by my question. okay, to your lawyer. But I just need to understand a little bit more about what happened on the evening, the overnight that we're talking about. What was it? Alcohol, drugs? What was it?
Drugs, Your Honor.
What drugs?
Meth.
Okay.
Mr. Harris has been sober for some time, and unfortunately, he got a ride from an individual that was offering him some housing. He was offered drugs, and in a moment of weakness.
Okay. Yeah, I just, we aren't here about guilt today, but I just wanted to understand a little bit more about it. Okay. And then Mr. Harris's mother, does she live with the grandmother, or she lives in Spartanburg or Greenville?
She does not live with a grandmother. She has her own residence.
Okay. And the grandmother's name is Miss. Anything else?
Yes, Your Honor, very briefly. Mr. Jovanovich mentioned he's not a flight risk, but Your Honor, if he's asking for home detention, he has an outstanding warrant for battery to police officers. The state does not believe that he would be a good candidate for home detention, and he is a flight risk. Lastly, Your Honor, under Section 22-5-510 and 16160, this is the kind of crime that the judge could be able to deny bond on. Nothing further, Your Honor.
Okay. All right. Thank you all. Sir, I know you haven't been in here this morning. You've not ever been before me before, as far as I know. I normally do draft my own orders, okay? And I'll do that as quickly as I can. Thank you all very much. Good luck to you.
Thank you.
Your Honor.
First degree, which is violent and most serious, carries 15 to life.